Today on America's Court with Judge Ross.
I'm
Do
sorry,
the guys
Your
have
Honor.
keys?
1 month. One time. The guys do not. Okay, Your Honor.
Yes.
I've been with
All
my
I
boyfriend
asked you was, do the guys have keys to
No,
the place?
they don't.
No, they don't.
So what was the one time you were referring to? The whole purpose behind law is to right wrong. I want justice to be something that isn't this foreign concept.
Justice knows no boundaries. The truth will be heard. Fair, firm, compassionate. This is America's Court with Judge Ross. Earl Montgomery is suing his tenants, Amy Cedars and Beth Dockery, in the amount of $7,843.75. He says the co-defendants had frequent guests in his home and ran up their utility bill.
All rise. Remain standing and come to order. This court is now in session. The Honorable Judge Kevin Ross presiding.
Ladies and gentlemen, you may be seated.
All parties have been sworn, Your Honor.
Thank you, Deputy Thomas. Mr. Montgomery, talk to me, sir. You're suing your current tenants, Ms. Cedars, Ms. Dockery, right?
Correct.
And the amount that we're looking at is $7,843.75.
Correct.
Why so much?
I'm looking for back pay on
Back pay as it pertains to what, sir?
to utilities and to the amount of people using the unit.
All right, so let's start with the utilities. You have a lease with these two women?
Correct.
Is it a one-year lease?
It's a one-year lease.
All right. And do you have a copy of that, sir?
Yes, I do.
I'd like to see it. Thanks. And this is utility bill. We'll get to that. This is also utility bill. All right, so you came prepared. This is the actual contractual agreement.
Correct.
A one-year lease, and it is from February to February. Now, there's a lot of handwritten things on here because initially it looks as though the amount was $1,200 and then it became $1,500.
Correct.
And you all agreed to that.
Yeah, what happened was we moved in, and after a month, my sister, who goes to college in the area, wanted to move in as well, and we asked Mr. Montgomery if we could do that, and he agreed, and we amended the contract from $1,200 a month to $1,500 a month.
And so the $1,200 a month were for the two of you.
Just the two of us.
And
And my
so-
sister Mary came in, and he increased the rent.
Now, why didn't you put, this is your sister?
Yes.
Her name is?
Mary.
And did you put Mary, did you have them fill out a whole new lease with all three of their names?
No, sir.
Any particular reason why?
Well, I was being kind and generous at the time, and I trusted these young ladies, and so I didn't put the third one on the contract.
But
at
you
the
did
time.
say, all right, instead of paying 12, now the three ladies will pay
Right.
$1,500.
Correct.
All right, and there's a lot of arrows and scribble going on here. Tenant cannot sue.
Yeah,
Your Honor, he did also put that the tenant cannot pursue any legal action against the landlord while we were signing.
While we were signing it. He did that like at the very end. Just
You
kind of
told
threw it
them,
in.
basically, what you're saying is, I have all the power and all the rights, and you have none. And the fact of the matter is, I don't know of any state that would fly. So that's not going to happen. You all are still in the property.
Yes.
Yeah.
The understanding was what regarding the utility? Who was responsible for water, power,
The landlord.
I was,
for all utilities?
yes.
So that amount of $1,200 included every aspect of the
Yes.
utility
Yes.
bills. You were okay with that?
To start with, yes.
Do you have other properties, sir?
No, I am a first-time landlord.
Okay. and ultimately, there was a good relationship, and you move in the first month, and within a month you're saying, we want to change the agreement to bring in your sister.
Yes.
And you were okay with that.
And I was okay with that.
But then, Ms. Cedars, you said he started hounding you.
He did. He started hounding us because we were allowing our boyfriends to come over and visit us.
And there's nothing in the contract that says that we can't have guests. So
Right.
essentially, he was saying that, we were having people over too often, and we were having too many people,
How
and we
often
weren't
was it?
making.
You have a boyfriend?
Yes.
So
You
do
have
I,
a boyfriend.
yes.
And
And
my
so does
sister
Mary.
has a
Okay,
boyfriend.
that's a lot of guys. So you didn't have a
So
problem.
I didn't have any concerns at that time.
Yes.
No. It wasn't
did the concerns
until
start?
I started getting the utility bills that I noticed that the bill went from $28 a month to $270 for 2 months.
Why did you choose to include utilities in the agreement to begin with?
I chose a lease off of the internet that did not include that.
But the
Because-
bills that you have given me here specifically deal with the water.
Yes, correct.
So the water usage was increasing.
Right.
And you believe the water usage was based on,
There being 6 people living in the place as
yes,
opposed to
yes.
just 3 people living
They're
in the
not
place.
living there. They're not living there. We have guests.
do
They're
you
like,
guys
"So
ever
we
come
get
over
home."
when you're not there?
No.
No, they're never there when
No.
we're not there.
Okay.
Coming up on America's Court.
I'm
Do the
sorry,
guys have
Your
keys?
Honor.
1 month.
One time. The guys do not. Okay, Your Honor.
Yes.
I've been with
All
my
I asked
boyfriend
you
one.
was, do the guys have keys? in
No,
place?
they don't.
No, they don't.
So what was the one time you were referring to?
And later,
that he was fatigued at the wheel, that he had fallen asleep, and that he is
That
the
is not
reason
true.
for this
That is
accident.
Don't interrupt him. I'm
happening.
listening to him.
closed captioning provided by. This is America's Court with Judge Ross. We're back with the case of Earl Montgomery, who is suing Amy Cedars and Beth Dockery to pay for unpaid utility bills.
Has
Going
there
on
ever been a
return.
situation where you have not been there, either one of you, but your boyfriend has been there?
No.
No.
Okay.
I had begged to differ, Your Honor.
Because you're living there.
Yes, I'm living there.
Are you pretty much home during the day?
I am retired, so I am there.
Are you being a Mrs. Kravitz?
There is a Mrs. Kravitz in the picture, though.
Oh, there is.
Yes.
Who's the Mrs. Kravitz?
Her name is Violet, and she's our next door neighbor, well, neighbor across the street. And she has seen the young gentleman using a key on several occasions going in while
No.
the ladies were not
Okay,
at
I'm
home.
Do the
sorry.
guys have
Your
keys?
Honor.
1 month.
One time. The guys do not. Okay, Your Honor.
Yes.
I've been with
All
my
I
boyfriend
asked you
one.
was, do the guys have keys in
No.
place?
No,
They don't.
No, they don't.
So what was the one time you were referring to?
I was sick. I was sick, and my boyfriend was coming in and out, and he was taking care of me during that time.
Okay. So ultimately, you have a little buyer's remorse.
Yes, Your Honor.
So you agreed to pay for the utilities. You've got this agreement here. They said that works for us. You're seeing these bills go higher and higher and higher. So what did you want to change the deal now?
So I want to change the deal.
Okay.
Correct.
And how much longer? And you're still in the lease period. You still have
Yes.
what?
Yes.
5
5
months.
5 months.
So you don't want them to pay during the time that they've been there so far.
Right. I want them to pay for future, half the water from this point
You want
out.
to change the deal.
Correct.
A deal that you drew up, that you had them sign
Yes.
for a year, that
Correct.
says, I will pay utilities.
Yes.
And you want to come in here and say, change my mind, make it happen. Yes?
Possible.
That's not going to happen. It's not going to happen. Because otherwise, if they can't rely on your word and your contractual terminology, then why sign a contract to begin with? This agreement that you pulled off the internets talks about security, rent, late charges, parking, storage, utilities, maintenance.
It says. Oh, go ahead.
I have another copy just in case he's written all over it.
Show it.
But
Ours has the same thing written at the
I
bottom.
don't see anything
though, that-
about additional people.
yes,
Neighborhood
nothing at all.
conditions, pets, entry. I mean, it's pretty thorough, except you don't list anything about
Well, yes.
people coming in.
Exactly.
You don't do that.
It didn't come with that.
So you want me to do it for you.
Correct.
I get it. Anything else? Based on the evidence and the testimony before this court, the gavel has to come down, however, in favor of the defendants. Lesson learned.
Right.
That contract has to be very specific. They have rights. They have an expectation that they can rely on what you set out in this agreement. Because other than that little business about they can't sue you for anything, which is not enforceable at all, they are not in breach. In fact, when Mary came as the third person, you should have written a whole other contract, added Mary, and that's when you should have said, here's the deal with guests, how many times they can come, and if we see this, I'm obligated and can enforce this condition where I either have all of you put on the lease or you move out. So you're going to have to suffer through it for a few more months, sir. But in terms of any sort of sway here, you can't meet your burden. Your matter is dismissed. Case closed.
Judge Ross has ruled in favor of the co-defendants. The plaintiff's claim is denied.
Lesson learned. Next time I'll find a better contract.
I think the judge was being really fair.
And I hope he can really put this behind us now.
And coming up on America's Court with Judge Ross.
He was fatigued at the wheel, that he had fallen asleep, and that he is
That
the
is
reason
not true.
for this
That is
accident.
Don't interrupt him. I'm listening to him. He's telling me the information I need to hear.
Closed captioning provided by. This is America's Court with Judge Ross. Mike Christie is suing his former employee Leonard Hodges in the amount of $5,000. He says the defendant unjustly pocketed company money. Mr. Hodges is countersuing for being hurt on the job.
So, Mr. Christie, you're suing for $5,000. Mr. Hodges, you're suing for $3,000. You were former employees, and we're dealing with an incident involving the collision of a truck.
Yes, Your
I
Honor.
have it right? Okay. After reading and considering the complaint, you prove your case first, sir. Go.
On May the 17th,
All right.
we had a last-minute run, and I knew Leonard was the man for the job.
All right.
He had
And
never...
the run was a road trip in the vehicle from where to where?
From our hometown to Wichita, Kansas, Your Honor.
And your hometown is?
Michigan, Your Honor.
But so most of your runs are over the weekend periods.
Yes, they are.
How long would it take in the truck to get from what city in Michigan?
Detroit, Your Honor.
You're in Detroit. How long does it take for that sort of trip?
It takes a couple of days.
Really? A couple of days?
Yes.
So you're on the road and something happened. You were driving the vehicle, so let me go to you.
I was on the way back to Detroit, and when I was making the turn, my wheel locked up, and I ended up hitting 3 parked cars.
And you're saying that it was the brakes that locked on you?
No, the steering wheel locked up on me. See, this is what happened. I made a maintenance report. We have to
Let me see that.
do a maintenance report on the vehicles to make sure that all the lights and the steering wheel, everything's working properly.
Yes.
Well, I did that, and I did notice that there was a steering wheel. It was stiff, basically. It
I
was
see
stiffing
that.
up on me.
Difficult to steer. And you did this report before this incident?
Before.
So, Mr. Christie, let me go back to you. Were you aware that this report was made?
No, Your Honor. I was never made aware.
You didn't receive this?
No, Your Honor.
Coming up on America's Court.
That he was fatigued at the wheel, that he had fallen asleep, and that he is
That
the
is not
reason
true.
for this
That is
accident.
Don't interrupt him. I'm
happening.
listening to him.
Closed captioning provided by. This is America's Court with Judge Ross. We're back with the case of Mike Christie, who is suing Leonard Hodges for negligence. Mr. Hodges is countersuing for personal injury.
You have your drivers fill out a vehicle condition report.
Yes, before every...
And is it your procedure that once they complete it, they turn it back into you?
Yes, Your
All
Honor.
right. My question is, when did you receive this condition report?
I didn't receive this condition report until the morning after he had already picked the truck
There was
up,
nothing
so-
he can do regardless. So they're closed on the weekend. There was no mechanic available.
So you're saying as soon as you got the truck, before you even started to Wichita, you had filled this report out?
That's right.
But there's no way that he would have received it because it was over the weekend and he wasn't going to be working.
That's right.
And what's this other condition report? You've given me 2.
Let me give you what I have.
Yes.
I'm
You
sorry.
wrote 2 condition reports, right, sir?
The other one was made after the accident, Your Honor.
This is the damage to the vehicle? Let's take a look at that on the plasma.
That's the truck itself, Your Honor. The whole left side
That
has been
looks pretty
damaged.
serious.
The front's been damaged.
That looks pretty
It
serious
was a pretty bad
because
accident.
I see here that based on where it all took place, you're lucky to be alive.
Yes, I am.
My issue is, why are you suing him?
Well, I received a call at midnight that night from my insurance company, and they said they can't cover the accident because they believed that he was fatigued at the wheel, that he had fallen asleep, and that he is the reason for this accident.
Don't interrupt him. I'm listening to him. He's telling me the information I need to hear. And so you're saying that the insurance claimant indicated that because he had dizziness, headaches, chronic tiredness, muscle weakness, okay, this is what they were saying was his state near or at the time of the collision?
Right, yes, Your Honor.
And they're concluding from that what?
That they are not liable to pay for the damages, that he is liable to pay for the damages because he is the reason that this accident happened.
Let's talk about the per diem. You give them $416.
Per month, yes, Your Honor.
And so the $5,000 comes from where?
The $5,000 is only half of the per diem that he's been collecting for the past 2 years that I hear he's been pocketing and not actually staying at hotels from my other employees. After this incident happened...
Stop. Let me go back to you. Let me go back to you.
That simply isn't
you
true,
saying
Doctor.
I heard, unless you can give me some proof of that, that does nothing for your case.
Right.
Now, what were you going to say?
I don't pocket the per diem. And besides that, it's allotted to us for us to complete the job, which I do. I have a good record with that company.
How long have you been working with them?
2 years.
All right. In the 2 years, have you ever had any problems with them?
I've never had any problems with him.
So at this point, all you're saying to me is, this man got into an accident. You don't think it was anything having to do with the steering.
Right.
Did you check it to see if there were some problems with it?
Yes, Your Honor.
And was there something wrong with the steering?
Yes, there was.
Okay. So I understand. Now let's go to your counterclaim.
I went to the hospital. I ended up losing a week work.
You lost a week's worth of work because of the accident.
Because of the
Can
accident.
you prove that, sir?
Yes, I have the bill.
Absolutely.
It's in your evidence, sir.
Judge Ross's verdict when America's Court returns. You're watching America's Court with Judge Ross. This is America's Court with Judge Ross.
So you have the hospital bill here, and you're also saying that you lost monies, and I see that as well. I got it. All right, fellas, based on the evidence and the testimonies before this court, let's start with the plaintiff's claim. You don't have one. It's dismissed. That was easy. All right, as it relates to you, sir, your counterclaim, I think you have proven your case. I think the vehicle had some issues with it, and you confirmed that when you did check the steering wheel. As it turned out, he was telling the truth. You have no proof that he was not using the per diem appropriately. So I don't have anything that undermines his credibility. It would make sense that he would have had some injury. He showed proof of that. In every respect, he's spot on. Your judgment will be $3,000 into the counterclaim. That is the order. Case closed.
Judge Ross has ruled in favor of the defendant. The plaintiff is ordered to pay $3,000.
I believe justice was served. I hope Mike learns his lesson because next time somebody could seriously get hurt.
He took advantage of me and my uncle's legacy.
Follow America's Court on Facebook and Twitter. This has been a production of Entertainment Studios.